Thank you, Joanne, and thank you, ladies and gentlemen, for attending. We understand these are unusual times, and historically, with the 11 of us, on the 11th annual broadcast of this, we would all be in one conference room, typically in Washington, D.C., gathered together. Unfortunately, because of the pandemic, that's not able to do that. But we really appreciate your joining us. The market has not changed dramatically in the sense that post-pandemic, pre-pandemic, in the middle of the pandemic, we still have very, very active enforcers. And so my colleagues and I, who are up on the screen now, will dive through this. As Joanne said, we'd love for this to be interactive. If you have questions, some of you have already asked questions, we'll try to lace them into the presentations, but as matters come up, please send them along. Or if you'd like just to shoot us a note and have a longer conversation, we'd be happy to do that. I'll go through my colleagues here. Joel Cohen is a leading white-collar lawyer across the United States, has been involved in major matters as a former federal prosecutor in the Eastern District of New York, and works with the global team literally daily. Kelly is head of our Hong Kong office. She was previously in-house at the General Electric Company, and for the last decade has been leading our Hong Kong office. And you're just as likely to see Kelly in Seoul or Mumbai, Beijing, as you are in Hong Kong. She's constantly on the road, and we have a large team that she leads in Hong Kong to take care of the entire Asia market. Benno Schwarz is a leader in continental Europe, but is fluent in Russian and lived in Moscow for about 5 years. He is very, very able throughout all of the issues dealing with the UK Bribery Act, FCPA, and local corruption statutes in continental Europe and in Russia. Patrick Stokes is a 17-year veteran of the Justice Department, one of the few people who had been head of both the FCPA unit in the Justice Department and the Securities Enforcement Unit in the Justice Department, tried the largest mortgage fraud case in the history of the United States as an assistant United States in the Eastern District of Virginia, and has been with the firm for about 5 years. Oliver Welsh is one of the great stories. First, he has participated in this before, but now he's participating as a partner. He's elected to the partnership effective January 1. We're honored to have Oliver as our partner. Oliver grew up in the United States, but has been in our Hong Kong office for a number of years. He's fluent in Korean, and like Kelly, you're just as likely to find him in Hanoi, Mumbai, New Delhi, or Seoul, as well as continental China. So those are the colleagues they'll be presenting. Each of them have deep expertise in the markets they're talking about, but have global expertise and are involved in matters cross markets and often in front of U.S. enforcers. Go on, next page, Joanne. Here's the agenda, and I think it's self-explanatory, so why don't we move right to the statistics, please. This is a chart that we started, believe it or not, back in 2001. And what we do is we track the trends. Like everything else in life, the trends are important, but they only tell part of the story. So if you look at this decade of trends, a little more than a decade, you'll see this aberrational 48 in 2010. That was a sting operation that was conducted by the Justice Department, where a couple of dozen people were arrested in Las Vegas on an undercover sting operation that the Justice Department operated. So that's why that number is so high. For those cases ultimately were, after a couple of trials, all dismissed. And you can see that in this year, even in the pandemic, if you think March is when the government stopped going to work in the United States. There's still very, very active cases in Department of Justice 21, SEC 11, and the disparity there obviously is you have to be a listed company for you to be charged in a corporate matter by the SEC. So you're almost always going to see the numbers for the Department of Justice be broader because it has a broader mandate on jurisdiction. So that you're quite aware, there was a resolution even last Friday in which Deutsche Bank resolved a matter that we at Gibson Dunn handled. People often ask, what would the comparable numbers look like for the UK Bribery Act? And even though it was implemented in 2010, there's still been total less than 10 enforcement actions under the UK Bribery Act. So while important and while the SFO has a very, very large staff pursuing bribery cases, the regularity of enforcement actions is much more intermittent under the UK Bribery Act than it is under the FCPA statute. We often say that if you build it, they will come, and that's absolutely true with the FCPA statute. There are approximately 35 full-time prosecutors in the FCPA unit in the Justice Department. There are nearly 40 dedicated enforcers at the SEC. So if you think there's nearly 75 people working full-time to enforce this one statute, almost inevitably you're going to see actions. At the SEC, they're both in the headquarters as well as many of the regional offices of the SEC. At the Department of Justice, they're all concentrated in Washington, D.C. Let's move to the next slide, please. So this is a chart that we started from the essentially inception of the statute we've tracked about essentially where are the allegations of misconduct coming from what country. And though if you pull it up on your screen a little larger, you'll be able to see it more effectively. But China now dwarfs everybody else, every other country. Nigeria, as you can see, is the number 75. But if you look at it, if we had this across a spectrum of decades, you would see that that would be more historic and not current. There are very few current enforcement actions arising out of Nigeria. The lion's share of them were earlier in the century, and then you see Mexico obviously coming pretty quickly. And I think if we had to predict, the Mexico statistics will exceed Nigeria in the next 3 or 4 years. And then after that, it really does become essentially a tour of the world. Virtually no location is immune. Virtually all markets have cases, and as a result of that, you can see them there. There is way fewer cases in Scandinavia, but as we know, the populations of Scandinavia, 5, 6, 7 million people in Norway, and Sweden and Finland, still not huge countries. Denmark, quite small countries. So while people point out to their ranking, the fact of the matter is there's just very few people comparatively to China and India and Mexico. Let's go on to the next slide, please. In terms of the charges resulting in fines, the fines for the last 2 years have just exponentially increased. Now, again, this is the law of small numbers. 1 or 2 hundreds of millions of dollars or $1 billion settlement can drive these numbers. But suffice it to say, if one gets caught in the vice of a FCPA investigation and you're an SEC registrant as well, there are huge consequences financially for an organization. And the Department of Justice, SEC, have become quite able at figuring out ways to extract larger fines and penalties using enhancements or using recidivist concepts to essentially to drive the numbers. So as you can see here, the numbers are eye-popping. And if we went back into the last century, the numbers would have been minuscule compared to now. It used to be that a $25 million settlement in the FCPA space was a massive settlement. Now it becomes essentially kind of the appetizer in terms of settlements. Let's turn to the next slide, please. So we keep this chart just to kind of provide people a spectrum of where the top 10 cases have come from. What's noteworthy about this? We think several things. A, no industry sector is immune. As you can see, financial services, telecom is obviously a substantial one, extractive industries, pharma, hedge fund, and defense contracting. So we're not missing much in terms of industry sectors being represented on the top 10 list. Two, only 3 of the top 10 are U.S. headquartered companies. And some outside the United States would say that suggests essentially a regime bias by the United States enforcers to go after foreign companies. I think the retort, which we find to be absolutely right, is that that this is where the evidence led, and this is kind of the calculation of the fines. In matters such as telecom, you could imagine a license in a country and for an emerging market country, what that would entail and the amount of profit that one could achieve from that. Excuse me. Because of that, you can see the numbers really move very, very quickly. All of these numbers, if you try to give this to an economist and say, okay, tell me what the rules are coming out of that just with these statistical numbers, I think any economist would throw their hands up and say, I can't figure it out. And their answer is, and that's the right answer. All of these are very bespoken settlements about whether issues of cooperation, when the cooperation kicked in, credit for cooperation, other enhancements dealing with recidivism and multi scenarios in terms of the misconduct alleged merged. So it's very, very difficult to extrapolate from any given resolution to another fact pattern. And you certainly can reason by analogy, but I think in our experience and all of the participants here have been across the table from the enforcers will be able to talk about their experience in that regard, is that you can't essentially say, take a number like the Siemens resolution, say, okay, let's take that, and then how would that apply? Siemens started really the massive numbers in 2008. We were fortunate to be the Siemens Compliance Monitors Council for 4 years. Benno Schwarz and I led that effort. But that's a unique experience that happened now 13 years ago. And how that number was calculated and derived at would be fundamentally different now. As I say, the sophistication and the essentially review process within both the Department of Justice and SEC is exacting, and every serious, significant resolution has to be approved at senior levels, and there is a striving for consistency among them. So would fully expect that if you have a matter, you have to look at it in a very, very individualistic way, using the foundational elements of these resolutions. Let's turn to the next slide, please. We point this slide out because this is a fundamental sea change. It started with Siemens and then was applied intermittently. But today on major settlements, it is almost a given that you're going to have a multi-country resolution. When I first started doing FCPA work in the early 1990s, a client would come to me and I'd say, well, we need to worry about the SEC and the Department of Justice. And they'd say, well, what about France? And I'd say, in effect, what about France? We don't have to worry about them, even if the conduct came out of France. Or what about the UK? Similarly, or what about Germany? Today, every matter has a multi-country dimension to it, if it's of anything of serious note. And this chart only lays out the numbers of participants. And I think what is noteworthy about it is beyond the total non-U.S. resolution amounts is the range of countries that participate. And as you can see, Singapore, Hong Kong, Malaysia, Sweden, Holland, France, all are participants in, and that's only the tip of the iceberg. There are examples after examples of countries that you might not think would be at the table in seeking an enforcement action. And Patrick Stokes can speak from his own experience being a prosecutor and being trying to organize the prosecutorial side globally on matters to bring it. It's certainly much simpler if it was just the SEC and Department of Justice, but if you add 3, 4, 5 countries to that dialogue with different legal structures and foundations, it makes it much more difficult. But it is, from our perspective, you always want to try to have a global resolution on the same day on terms that seem consistent, because otherwise you just set yourself up for seriatim enforcement actions. Let's turn to the transparency slide. I think this hasn't changed. If we looked at this over the last decade, it might be rosier or more yellow, from time to time. But on balance, the hot spots have remained for a long period of time, and that's why we focus on the ones that we're going to dive into right now. And with that, Kelly, why don't we jump right into China? We have just an enormous amount going on with China. Obviously, there was the China Initiative in the now departing the Trump Justice Department, whether that stays current. But I think one of the things you do such a great job, Kelly, is diving into what's happening parochially within China, which is in some ways a bigger story than the China Initiative. So can you jump into that and educate us about what's going on in the China market, please?
Very happy to do so. Joe, let me start by just echoing a point that you made about the global resolutions. One of the things that you pointed out is the extent to which there are multiple countries participating. Goldman Sachs was noteworthy, not just because it was a blockbuster U.S. resolution, but it was also a record-setting resolution here in Hong Kong. So it's the largest ever SFC penalty, $350 million. And obviously that was part of the global resolution for Goldman Sachs. So I'll move to mainland China now. Obviously, China is an incredibly important market, has been for years for virtually every multinational. 1.4 billion people, very attractive consumer base. There's been a long-time focus on the growing middle class and on the need for multinationals, large and small, wherever they are headquartered, to be in the China market. That continues, although it has been a difficult year, particularly the first half of the year in China. One point I did want to note, though, is the extent to which China is still heavily reliant on exports. The China market is an inbound market, but also very much an outbound market. And we'll talk about some of the sanctions impacts coming out of the Trump administration as we go through the China section. Obviously, growth down substantially. GDP estimated to be down 2% this year. The pandemic obviously hit in China early, and China had the economic effects of the pandemic through the first half of the year, started to see the markets pick up in the second half. But it has been a struggle for companies to achieve the growth targets that they set at the beginning of 2020 in the China market, just like it has in many markets around the world. One of the things that we have pointed out in recent years is the extent to which China has been a growth engine for multinationals and the increasing pressures in the China market as sales teams move to try to meet growth targets. We see increasing compliance risk. And that's going to be one of the themes for our discussion today, the extent to which the pandemic continues to drive compliance risk in markets, including in China. The corruption landscape in China continues to improve, at least the perception of the corruption landscape. China's Transparency International Corruption Perception ranking is up to 80. That is a substantial increase over the last 5 years. Largely that is being driven by a sense that the government and Xi Jinping himself continue to remain focused on eradicating corruption, particularly because corruption is viewed as a threat to party stability. The anti-corruption campaign continues. If you look at the numbers year in, year out, and 2020, despite the pandemic, still very substantial focus. We've talked in previous years about the number of officials who are disciplined every year by the Communist Party disciplinary organization. This past year, January 2020 through the end of the year, more than 100,000 officials who were disciplined for violations of what are referred to as the 8 rules, which include fraud, embezzlement, and corruption. Those enforcement actions are coming across provinces at all levels of government and across agencies and ministries. So it is a very widespread campaign. There are obviously certain focus areas, but the message that I would want you to take away is that continued focus on government officials at the highest levels and lowest levels continues unabated. China continues to develop the criminal law that applies to bribes and corruption, among other things. Very substantial amendments to the PRC criminal law will become effective on March 1st of this year. So they were passed by the National People's Congress in December. Just a few points that we want to bring to your attention today. The first is the continuing focus by the Chinese government on commercial bribery. So the amendments include a provision that raises the criminal penalty for private individuals who are referred to in the legislation as non-state functionaries who are convicted of commercial bribery involving very large sums. The maximum term of imprisonment has increased from 10 years to potential life in prison. That puts the penalties for pure commercial bribery on par with the penalties for official bribery. There has also been a continued focus, and we've seen it in enforcement actions over the last few years, on the use or misuse of Chinese human genetic resources. There is now a criminal offense if someone illegally collects human genetic resources or transports those resources abroad. There have been historical enforcement actions under the state security enforcement apparatus. There is now an enforcement mechanism under the criminal law. There's also a biosecurity law, which came into effect in October of 2020 that lays out regulations on the collection and use of human genetic resources and administrative penalties if you breach those provisions. And then the last point that we wanted to bring to the audience's attention is the continuing focus on healthcare. Healthcare as a sector and anti-corruption efforts in healthcare continue unabated. And one of the new amendments in the criminal law codifies criminal code violations for those who fabricate records in connection with drug registrations. And we'll talk a lot about the focus in the healthcare sector because there's an awful lot happening there. One of the things that I've mentioned at the start is the extent to which there are now countervailing sanctions between the U.S. and China. And it is making it much more complicated for multinationals who are doing business in both markets to comply with regulations that in some cases are mutually incompatible. The first I want to talk about is the unreliable entities list. So in September, China's MOFCOM, Ministry of Commerce, created an unreliable entity list. And Chinese authorities they have not yet, but they may add foreign entities to the list if they in some way endanger national sovereignty, security, or the interests of China, or if they somehow decline to engage in normal transactions with Chinese entities. The potential penalties, very open-ended, include restrictions on imports or exports, potentially restrictions on investment in China, so foreign direct investment, immigration provisions, as well as fines and undefined other necessary measures. No entity has been added to the list to date, but we continue to watch this space along with other areas where it's potential that multinationals can get tripped up. Sanctions and countervailing legislation in China is one of the fastest moving areas for focus. So those of you who have business operations in China need to be watching very carefully what is happening with the Chinese legislative and regulatory developments because they are happening fast and furious and they have very substantial potential impacts. We've talked in previous years, those of you who have been with us for the last 10 of these emerging markets webcasts will remember that in the past we've talked about the fact that Shanghai has long imposed heightened anti-corruption requirements on corporations. You may remember talking back in 2015 about the limits that Shanghai imposed on business activities for family members of senior government officials. That's a Shanghai-specific set of guidelines. This year brings a focus in Shanghai on commercial bribery and compliance programs. So effective as of January 1st of this year, the anti-unfair competition regulations that were passed in Shanghai, among other things, impose limits on accepting bribes, so not just giving bribes, but accepting bribes, no monetary threshold for commercial advantage, either directly or indirectly. Companies are, and this is an important theme that you'll hear throughout the webcast today, focused by global regulators, including in Shanghai, on ensuring that companies have effective internal controls, that they've built compliance programs that are reasonably effective. And if there is a potential enforcement action, the authorities in Shanghai will expressly review the extent to which the companies had an effective compliance program in place. The government is also providing additional guidance on what it expects. That is going to be with regard to anti-unfair competition enforcement actions, with regard to what's considered reasonably effective compliance programs. But this is a trend that we are seeing in a variety of jurisdictions, including, as Oliver will talk about a little bit, in India. As I mentioned, the enforcement actions are very much targeted at senior level government officials, and the penalties are significant. So in terms of sector-specific risks, a number of very senior government officials in the energy sector, National Energy Administration, CNPC, a lot of government officials in the finance and banking sector. Just two I want to call out, both of which drew death penalty sentences, one of which has been sentenced with a possibility of reprieve, the second without. So the first one is Hong Kong Bank, The amount of money that was allegedly embezzled and secured through improper gains is astonishing. It's more than 1.4 billion U.S. dollars. It brought a death sentence with a 2-year reprieve. The second capital punishment sentence for an economic crime came very recently. Lai Xiaomin, who's the former head of Huarong Asset Management Company, was sentenced to death for bribery, embezzlement, and bigamy. He was alleged to have collected bribes more than 270 million U.S. dollars over a 10-year period. He's a former bank regulator, so former PBOC regulator, but the misconduct was while he was the head of Huarong Asset Management, a role he took over in 2009. He has been, as I said, sentenced to death. There's a possibility of appeal in that case, but it's not the standard Chinese death sentence that includes the possibility of reprieve after 2 years. So that's a very significant penalty. It shows you the extent to which the government continues to want to underscore the government's commitment to ensuring that it is taking enforcement action, particularly against those who misuse their government roles to obtain ill-gotten gains at levels like these. Obviously, all of these entities are government-owned and government-regulated, as many of the industry sectors are in China. And so if you're dealing in financial services, if you're dealing in the energy sector, or as we're about to talk about, if you're dealing in the healthcare sector, you need to be particularly alert to the risks. So on the healthcare sector, I'm just going to spend a few minutes just bringing to your attention some of the key developments over the last year. First, let me start by saying that the Chinese government has long been targeting the potential for graft, corruption, and kickbacks in the healthcare industry. What is happening now is longstanding practices are very much under scrutiny. So in August of last year, the Chinese government rolled out a nationwide campaign which included audits of public hospitals, cracking down on improper payments that are disguised as very customary marketing and promotion activities, such as donations, academic sponsors, and speaker fees for doctors and other healthcare practitioners who are speaking at conferences and private events.
Kelly, this is similar to what has happened a decade or two earlier in the United States, where there's keen focus on the interrelationship between the independent healthcare provider and the institution, whether it's a university or a hospital healthcare provider. Correct?
Absolutely. Absolutely. And I think, Joe, it's motivated in many ways by the same underlying impulses. A desire to make sure that healthcare dollars are spent on public healthcare, public anger when that's not the case. Just the sheer volume of procurement that takes place, particularly in China, in public hospital sectors. A realization that healthcare practitioners' judgment might be influenced in a way that wasn't appropriate for public health, for individual patient decisions by things of value that were given to them. Okay. Next point that we wanted just to bring to your attention is in November of this past year, the PRC authorities issued what is effectively a credit rating system for both medical device and pharmaceutical manufacturers, including their supply chains, distributors, logistics companies, and company agents. The manual prohibits any form of bribes or kickbacks to any public healthcare facilities. It also prohibits falsified documents. If you run afoul of these regulations and you commit what is referred to as a particularly suspicious violation, you can be banned from transacting with public procurement agencies. So a full public procurement ban can be the result. There's a provision that requires companies to sign a compliance declaration, and most particularly to report to the provincial authorities any judgment or fine related to bribery or corruption. Again, we're starting to see in a variety of markets not just requirements that in the healthcare sector in particular and any sort of state-owned sector more broadly, that companies comply with specific requirements, but also a requirement that when they don't, they have to report to the authorities, which is obviously something that is still evolving under these regulations. Okay, next healthcare trend that we wanted to bring to your attention are the requirements, the administrative measures around marketing authorization holders. Marketing authorization holders, if they have representatives, employing representatives, whether they're direct or contract organizations, who are providing marketing information about medical products, including academic programs, to healthcare practitioners, they need to be registered. And if they're going to be conducting promotional activities, they need to do so with the consent of the medical institution that employs the healthcare practitioner. That includes a prohibition on direct benefits to HCPs, so things like, as I was just talking about, donations, sponsorships, financial aid are now prohibited under these administrative measures if you qualify as a marketing authorization holder. The definition of marketing authorization holder does include subsidiaries of foreign companies. So Chinese-based foreign MAH entities are subject to these requirements. So if you're in the healthcare sector, you make sure that you understand and are thinking through how you're going to implement these provisions. I'll stop there, Joe. I don't know if there are any other points you wanted to make on healthcare before we move on to some other trends.
I think, Kelly, what you're trending is if you overlaid what OIG and HHS and what the enforcers in the United States are doing and compared it to China, the similarities are so striking. They're trying to get to the heart of the relationship between the provider, who's spending, as you say, enormous amounts of money, and the company who is providing the product, and essentially examining that relationship and essentially tightening it up dramatically. There have been a resolution that we were involved in last summer on behalf of a major pharmaceutical company that OIG has promulgated new regulations or new requirements and strictures associated with the intersection of in-person visits and a whole range of other ways of how companies historically have gone to market. So what we'd urge people on the call to do is to really examine carefully how one goes to market in China, because it's beginning to echo very similarly to the trends we're beginning to see in the United States about how people go to market. And Kelly, maybe it's worthwhile as well, as since we're talking about this, we've had several questions that have come in about China, and essentially going back to the original chart on the statistics of the explosion of China cases over 100. A question comes in: were those China cases related to U.S. subsidiaries in China or China companies listed in the U.S.?
Yeah, so those are Chinese government officials. So that's part of the party disciplinary apparatus. So they may, in some instances, be the recipients of improper things of value from a foreign multinational, including potentially a U.S. headquartered or U.S. listed company. But that party disciplinary apparatus focuses just on government officials.
Right. And on the original statistics of the 108 cases, those are, I think, almost exclusively U.S. listed companies, and the conduct is in the Chinese subsidiary. What we haven't seen yet, have we, Kelly, where there's been a U.S. enforcement action and then the Chinese enforcers have piggybacked on that. It seems that their enforcement regime follows their own patterns and approaches. Is that correct?
That's correct, but there have been cases, GlaxoSmithKline being one example, where there are Chinese enforcement actions and actions by global enforcement regulators. So it's not usually the pattern, as you know well, Joe, that the U.S. authorities bring a case and then the Chinese authorities bring a case, but there are often cases that are happening potentially in parallel, and conduct in the PRC is very much the focus of FCPA enforcement actions. And we get a lot of questions, usually when we're in China talking about these issues, about whether that results from a particular focus by the U.S. Department of Justice and SEC on China. And the answer is yes, but not really. The largest driver is the fact that every major multinational is doing business in the China market, many of them through third parties, which are the single greatest source of risk. Because of the size, scope, cultural issues, geographic reach in China, many multinationals will go to market in China through third parties. That drives risks, that drives enforcement actions. And we'll talk about a couple from this year.
Right. And maybe just, we're getting lots of questions in on China, not surprisingly. One client comment comes in from a good client who asks, can you provide more color of the interaction between enforcement entities in the U.S. On documents and state secret issues and investigations generally? One of the things that the government-to-government relations are very modest and not substantial at all. So unlike all these coordinated investigations that we highlighted at the very beginning of the session, there are not that level. There's not that level of coordination, and the way state secrets works. There's Patrick Stokes will be able to jump in on this. There's just not substantial coordination at all between the two. There is one example most recently, the Luckin Coffee resolution with the U.S. SEC, in which the securities regulator in China allowed documents to come to the United States after they reviewed them and be delivered to the SEC, which formed the basis of that resolution with Luckin Coffee. Luckin Coffee was an IPO that listed on the NASDAQ in the United States that seeks to be kind of the Starbucks of China. And that resolution showed coordination, but short of that, I think there's very little. Patrick, do you want to jump in on that, please?
Sure. Yeah. Historically, there's been almost no coordination at all between enforcement on anti-corruption matters. On enforcement matters, the coordination has been at a policy level and at a ministry level, but not at the enforcement level. But part of the reason U.S. enforcement has surmised is that cooperation between the governments would likely require Chinese officials sharing information with the U.S. about its own government officials' corruption. And so the Chinese government has, not surprisingly, found that unappetizing. But, in some types of cases, U.S. law enforcement has cooperated with China, but it's pretty rare and far between. And in recent years, with the trade antagonism, the larger law enforcement relationship has become even more antagonistic.
And we'll talk a little bit about the state secrets and the China blocking statute, Joe. But one other positive development that we did want to highlight is, one of the frustrations for many years, certainly for the U.S. SEC, but also more broadly for the investor community, has been that Chinese securities regulators refuse to allow Chinese headquartered companies that were listed on markets outside of China, including in Hong Kong and the U.S., to share audit work papers. There's been a very small breakthrough this past year where Hong Kong's Financial Reporting Council was able to receive initially audit work papers for 7 PRC-listed companies. Then that was expanded for companies that are listed on the Hong Kong Stock Exchange. That's important because one of the trends that we're starting to see is Chinese companies choosing to list outside of the United States or to shift their listings to Hong Kong. So Hong Kong is going to be increasingly important as a locus for listed companies that are Chinese headquartered. And so this development in terms of the release of the audit work papers, essentially the government determined that they did not constitute state secrets and then passed them to the Hong Kong authorities, which is a positive development. Still no breakthrough, though, on China allowing representatives of the PCAOB to review audit work papers for Chinese companies. As Patrick said, one of the issues has been the lack of the sort of escalating tensions between China and the U.S. And in some ways, that has been crystallized in the International Criminal Justice Assistance Law, what is generally referred to as the China Blocking Statute. The China Blocking Statute says that no Chinese entity or individual, even if that's a Chinese subsidiary of a foreign company that is operating within Chinese territory, is allowed to provide foreign countries with evidence of any form to assist in connection with a criminal case. We are routinely navigating through the China Blocking Statute when we are involved in criminal investigations, particularly in the United States, where U.S. authorities want documents, data, information, access to witnesses. If it is a civil, administrative, or internal investigation, that's one thing, but the tricky part is when you know that there's some possibility that it may turn criminal, or if it is criminal. There's supposedly a consent mechanism, but the mechanism, the steps by which you would trigger that mechanism are not clear. It's also not clear what the penalties are for a violation. That China Blocking Statute marries up with the state secrets laws and the Chinese securities laws, both of which impose obligations on Chinese companies to prohibit the transfer of information outside of mainland China without approval from the Chinese government. So with regard to state secrets, broadly defined, not exactly clear, can be retroactively designated. The Chinese securities laws cover anything that is related to the securities activities of Chinese companies cannot be shared with foreign regulators. So when you take these 3 laws together, it makes it enormously tricky to navigate through an investigation, particularly to the extent that there are potential criminal violations of the securities laws. So our takeaway here is you need to make sure you have very experienced both international and PRC counsel to help you navigate through these. Okay.
So why don't we just try to move through the rest of these, please?
Yep. So just noting for the SEC's discomfort with Chinese headquartered U.S. listed companies, additional requirements, SEC disclosure guidance that was issued in November, and then the Holding Foreign Companies Accountable Act, which is again driven by anxiety about the lack of PCAOB access to audit work papers. As I said, lots of enforcement actions year in, year out in China. Just wanted to highlight 2. One is the Airbus settlement, nearly $4 billion global settlement. DOJ deferred prosecution agreement, $580 million. The case illustrates, among other things, the dangers of making payments through third parties. In this case, some of the payments were flowing through bank accounts in Hong Kong, supposedly for services being rendered in the PRC. The other issue that we continuously see, perennial issue in our investigations, is the use of service contracts as a way to get funds to make improper payments. it is very difficult sometimes to have proof of performance on a service contract, and so it can be the preferred mechanism. The Cardinal Health case, again, illustrates a perennial issue, which is marketing funds being used to give things of value to decision makers on commercial transactions. And that is, again, an issue that we have seen year in, year out, both in enforcement actions and in the investigations that we lead. So a bit of a whistle-stop tour on China, but I will turn over to Oliver to take us through India.
Hello. Thank you, Kelly, and great to be with you all. Hello. Every year we cover India, and for good reason. I think that this year it becomes an even larger player on the stage, and that is due in large part to places like China becoming a little bit more complicated to do business because of the legislative changes and also the sanctions coming out of the U.S. and elsewhere. So a lot of companies are looking to India as a large market in which to do business, but it's not without its risks, and that's what we're going to discuss today. So looking at slide 28, just walking through a few of the important statistics here. First of all, 28% is the percentage of the middle class in India. This is projected to be the largest middle class in the world by 2035, and this is the result of a lot of aggressive anti-poverty initiatives by the Modi administration trying to create a broad middle-class consumer base to drive domestic consumption. And you can see why other companies want to do business in India to take advantage of that. Still in India, there are restrictions on foreign domestic investment and how companies can do business in India if they are not India headquartered, but still India remains one of the top recipients of FDI at USD 51 billion, according to the latest statistics that we have. India was good at the beginning at staving off a lot of the ill effects of the COVID-19 pandemic, but ultimately they succumbed. Now they have the second highest caseload, a low case mortality, but that the economic fallout of that is still unfolding. The economy is predicted to contract by 10.3% in 2020 and 2021, due in large part to COVID-19 issues. It is predicted to bounce back 8.8% by the end of 2020. It's important to note that that is very much a bounce back. So that is dependent on a lot of things. Most importantly, the pandemic getting under control, but that is coming back after such a deficit. So going over to slide 29, the story that we want to tell about India is that if you look at a lot of metrics, enforcement and corruption-related indexes, it seems as though corruption is going down. But as with a lot of things in India, if you peel it back a few layers, that doesn't actually tell the full story. Over the past decade, Transparency International's Corruption Perception Index has moved India up 11 spots. The World Bank also notes that India has improved markedly in control of corruption. And so it seems that they are doing well, and in a lot of ways they are. But if you look at what's going on the ground, that tells a little bit different story. Transparency International also conducted a survey called the Global Corruption Barometer. That noted that nearly 40% of Indian public service users paid bribes in the past 12-month period. That is the highest among all Asian jurisdictions. And then also in the box on the right, we discuss a few initiatives that are slowing. We'll talk about the Lokpal a little bit later, but the Whistleblower Protection Act, which was passed in 2014, aimed at providing protection for whistleblowers, has stalled at the executive level. And commentators are speculating that that is because those executive branch officials don't themselves want to be the subject of whistleblower reports. Turning to the next slide, going over the legislation very quickly. Prevention of Corruption Act is the main piece of anti-corruption legislation in India. Like a lot of laws around the world, it prohibits public servants from accepting bribe payments, and that's really where the focus was for a long time. 2008 comes along, and the Indian government passed legislation that's focused now on the supply side of bribery, so the bribe givers in the private sector. According to these 2018 amendments, the giving or the promise of an improper payment is now prohibited. Now, there's a few exceptions here. A bribe giver, for example, will not be liable if they can prove that they were compelled to give the bribe and they report the bribe within 7 days to law enforcement authorities. It's very difficult, however, to prove that you were compelled to give a bribe, and generally we don't advise that our clients rely on this exception. Also, in contrast with the U.S. FCPA, there is no exception for facilitating payments under the Prevention of Corruption Act. Over to the next slide, focusing a little bit more on the government's efforts to tackle the supply side of bribery. The amendments in 2018 have very important implications for commercial organizations. So first of all, organizations can be held liable for the acts of their employees if their employees give an improper payment to gain an advantage for the commercial organization. Commercial organizations can avoid this liability, and this is an important point, if they can show that despite the employee's act, they had in place adequate procedures designed to prevent it. So again, this highlights the importance of compliance programs, robust internal controls. We don't yet know what adequate procedures means. We're waiting for government guidance on this, but in the meantime, follow a lot of the global best practices that we are going to talk about today. The Companies Act here at the bottom also has important implications for companies and their directors. Under the Companies Act, the directors of all companies are required to certify annually that their companies have proper systems in place to ensure compliance with all applicable laws. Over on the next slide, the Companies Act also imposes certain disclosure obligations on companies. We talk about these year on year because they continue to cause confusion. So under the Companies Act, statutory auditors must report to the government instances of fraud committed by employees of the company. So where there is a fraud, and that is broadly defined, not specifically to include bribery and corruption, but several influential organizations, including the Institute of Chartered Accountants, have urged auditors to include in the definition of fraud bribery and corruption. And so to the extent that these auditors uncover that within these companies, up to 10 million rupees, auditors must report to the company, which then is given a time to respond, and the responses and the report are forwarded to the government. For frauds less than that, the auditors notify the company's board of directors. The board is then required to disclose details of that in its annual report, which is then filed with the registrar of companies. So still something that is causing consternation among companies trying to do business in India. Over to the next slide, 2020 brought additional disclosure obligations that are similarly causing confusion. One is related to whistleblower reports. So under new rules, companies must disclose whistleblower reports to the auditors. The auditors, in turn, must disclose whether they have considered these whistleblower reports when drafting their audit reports. Also, very importantly, the Securities Exchange Board of India in September determined that companies listed on Indian exchanges must disclose every time they initiate a forensic audit. This is irrespective of materiality. It's irrespective of the reason for the forensic audit. So when companies start an audit, and again, these are companies that are listed on stock exchanges, they have to report to the Securities Exchange Board the fact that they've initiated the audit, the reasons for the audit, and they must turn over the audit report. So this obviously has a lot of implications for companies who are trying to do internal investigations, who want to bring in forensic auditors to assist with that. It has privilege and confidentiality considerations, and it's very new, and we don't yet know what this means. So more than ever, it is important to engage auditors who are knowledgeable of this, who know the nuances of it, and don't just rush to overly disclose, or who forget to disclose the things that they're supposed to mention to the auditors. Going over to the next slide, the message here is that India continues to be a land of many regulators, most importantly the Central Bureau of Investigation, the Central Vigilance Commission, and the Enforcement Directorate. So all of these enforcement agencies may initiate investigations into companies doing business in India, and that number is growing with the Lokpal, which has been a long time coming and finally got operationalized in March 2020. The Lokpal can investigate violations or alleged violations of the PCA including bribe giving, including violations committed by private companies or individuals. As I mentioned at the beginning, going over to slide 35, the trend in enforcement shows that cases registered under the PCA are down. If you look starting 2017, 2018, and 2019, we see a dip in cases registered under the PCA against government officials. So this is the Central Bureau of Investigation initiating cases against government officials. So this may suggest that enforcement is down, but again, that doesn't tell the whole story. So under the 2018 amendments, there's a new provision, Section 17A, that requires prior sanction or prior approval of the government before the CBI is allowed to initiate an investigation of a public official. Previously, only the prosecution of a public official required prior approval. So under these amendments, the government is supposed to take no more than 3 months to give that approval, but in reality, that's not happening. So a dip in this enforcement may be coming because the CBI is just finding it harder to get approval to register cases under the Prevention of Corruption Act from the government. But again, that doesn't tell the full story. So over on the next slide, the decline in local enforcement numbers doesn't necessarily reflect the situation on the ground. There are still massive corruption scandals and investigations ongoing, and the CBI is taking aim at companies in other ways. So there's currently a long-running investigation into now defunct Indian Airlines and their purchase of 43 jets from Airbus. The Enforcement Directorate is looking at whether that contract involved improper payments. Indian authorities recently charged the CEO of one of the largest Indian banks with providing favorable bank loans to private companies, which in turn invested funds in businesses held by the head of that bank. The CBI also announced that they have registered nearly 200 cases against private companies for alleged bank fraud, siphoning funds out of mostly state-run banks. So the takeaway here is that the CBI is going to do everything that it can to keep its enforcement numbers up. It does not require prior government approval to initiate a PCA investigation into a private party. That's only required for an investigation into a government official. The CBI, the Enforcement Directorate, the Central Vigilance Commission can bring cases under other laws, including those involving bank fraud, foreign exchange, and import and export violations. And also the CBI has noted that their enforcement is down in large part because of operational difficulties due to the COVID-19 pandemic. So look for that to increase as the government gets a hold of that situation. Finally, the single FCPA enforcement action in India was the Beam Suntory matter. A few interesting things to note here. This was a $20 million settlement with the DOJ to resolve allegations that Beam's India subsidiary made improper payments through third parties to obtain favorable product placement in state-run product depots, most notably the Indian Army stores and those on military bases, and also to obtain permits. A few things to note here. The DOJ noted that Beam India employees, including those in the legal department, failed to rectify compliance breaches. They had found these breaches. They had heard about them from accounting and law firms. And not only did they fail to fix them, in some cases they actively obstructed compliance assessments and remediation, including those in the legal department. The DOJ also noted that Beam did not perform pre-acquisition due diligence on Beam India, which had a long history of making improper payments. And also, interesting to note that this was the same case essentially that happened in 2018 with the SEC. Same set of facts, same alleged improper payments, and in that case, the SEC fined Beam $2 million. Normally, the DOJ would provide credit for the fine paid to the SEC, but they declined to do so in this case, saying, quote, Beam did not seek to coordinate a parallel resolution with the department. We don't exactly know why Beam didn't seek to do this back in 2018, but it does underscore the importance of doing so. So when you are conducting settlement negotiations, think broadly, make sure that you are having those negotiations with all the concerned parties. Other lessons from this, make sure that you're conducting pre-acquisition due diligence to uncover those prior lapses. And of course, even if you have legal and compliance department employees, they also need to be trained and monitored to understand that they are really the company's strongest line of defense against corrupt conduct.
Oliver, thank you for the deep dive into India. We have one question that is relating to Korea, and since you're often doing Korean cases, you're fluent in Korean, as I mentioned earlier. Can you speak generally about the Korean bribery landscape, please?
Yeah, so Korea, it's an interesting place. You know, we have a President Moon Jae-in, who came in following the impeachment of President Park Geun-hye, who was impeached for corruption, who was impeached for taking payments funneled through sham charitable organizations. And so really the landscape is highly focused on corruption issues. The president has promised to root out corruption in the country, but as is often the case in Korea, he and his own administration has fallen into scandal. Most notably, his Minister of Justice has feuded with the top prosecutor in the country, and has been accused of trying to obstruct that prosecutor's efforts to root out corruption in the prosecutor's office. Korea also has a relatively new law, the Kim Young-nan Anti-Corruption Graft Act, that contains very specific prohibitions on things like gift-giving, meals, entertainment, what you can give at weddings. And the prosecutor's office has been very, very active in enforcing that. We have a lot of clients coming to us with Korea cases, and it's a very nuanced jurisdiction. It's highly dependent on the culture there in Korea, and what has gone on historically. So Korea is also a very interesting jurisdiction.
Thank you, Oliver. Joel, why don't we jump into Africa, please?
Okay. Well, hello, everyone. This is Joel Cohen. I've been privileged in years before to talk to you about Africa. And one of the themes I'm going to be covering in my time is something you've heard before, looking at this first slide, which is that while many investors and others that look at Africa who are not sophisticated tend to look at it totalistically as if everything is the same in Africa. In fact, that's not true. The investment opportunities, the corruption risks differ widely, and having an understanding of how to operate in Africa doesn't just mean Africa. It means which sector of business, it means which country, it means which region of which country, and it really does differ. But as you're going to see from the slides that I'm about to present, with the economic downturn and the impact of COVID, unfortunately, Africa tends to see the most extreme impacts of economic changes like that, or global changes, and that's absolutely true this year. So looking at the market characteristics on this slide, this is an overview slide that provides just some current market statistics as we do every year. As of the beginning of 2020, the Africa Development Bank expected a 3.9% real GDP growth across Africa, and that was expected to accelerate to 4.1%. But that was before the advent of COVID-19, and those were very significant GDP growth rates, significantly greater than across the globe, which reflected in many years' trend towards increased economic harmony and frankly, strengthened efforts to combat corruption. But then you see the impact of the pandemic. There has been a contraction in African economies, in some cases as much as 11%, for example, in the case of South Africa. GDP losses that could approach, at this point, almost $200 billion. Very significant defaults on loans. The recovery in 2021 is expected to result in a 3.1% increase in real GDP growth, but these are based upon numbers from October. The World Bank, which itself might be out of date in the way that sadly the COVID virus is now beginning to in a latent way affect the continent. If we could move to the next slide, this is a slide that also talks about the impact of COVID-19 Summarizing the scope again of the pandemic's impact, as I've mentioned, it highlights the impact on 4 of the continent's regional economic leaders, and shows a slowdown in actual GDP growth rate. As you can see, the most profound number, an estimated increase of 40 million Africans who will become extremely impoverished as a consequence of COVID-19 and its economic impact. That eviscerates incredible efforts over the last 2 decades to reduce those numbers, and now in one fell swoop in 1 year, because of this, 1 year and a half, it could increase that number back to places that it hasn't been seen for years. Where we can expect the corruption to rear its head in Africa is in the area of construction, housing, medical assistance, and all of the investment thereof as countries begin to combat and recover from COVID. If we could move to the next slide, the corruption climate. As an example, you see here a September 2020 Transparency International report on issues related to COVID-19 humanitarian and economic aid revealed that governments in Nigeria and in Zimbabwe had received millions of dollars in international humanitarian aid, but had released absolutely no information about how the aid was being distributed. There are now already beginning investigations throughout Africa about where that money has been used and how it's been used. There's a UN Development Program report that highlights that some countries have relaxed safeguards on compliance, on oversight, and accountability, because frankly those things cost money to staff, and this has resulted in a slide in corruption risk perceptions, which is obviously not the direction that Africa has been going generally before the advent of COVID. If we can turn to the next slide, please, regional cooperation in anti-corruption efforts, to dig a little deeper into some of the developments we've seen over the last year. So in July of 2020, the African Union and its advisory board commemorated the 4th edition of its Africa Anti-Corruption Day. This has become a very significant event for those of us who do work in Africa and visit. It's taken very seriously by the legal and compliance, the legal and attorney general staffs in various African countries. Another positive development, the convention. This convention was ratified by Equatorial Guinea and Tunisia. Especially Equatorial Guinea is a major development in that anybody who knows anything about corruption in Africa knows that that's a country that's perceived to have amongst the worst problems in corruption. So this is a meaningful change. There have been many other statements that are enumerated here in these slides about efforts, joint statements by the African commissions and African groups, the Advisory Board on Corruption, various groups that have been organized and having a meaningful impact across the continent in combating corruption as it affects cross-border activity within Africa. If we can go to the next slide. So this talks about some examples, some specific examples. In Angola, another country with a very, sadly, strong corruption reputation, there were some very strong, positive developments there in combating corruption. The son of a former president was sentenced to a 5-year jail sentence, along with the former governor of the National Bank of Angola. There is not a history of that sort of senior-level corruption prosecution happening significantly in Angola. In the DRC, the Democratic Republic of Congo, a former chief of staff was sentenced to 20 years for embezzlement. Again, these are developments that we have not seen in those countries, that level of high-level corruption prosecution in recent years. On the next slide, a continuing discussion of developments in other countries, and these are just examples because, as Africa is a large continent with many different countries to address. In Kenya, the Ethics and Anti-Corruption Commission has begun to investigate COVID-19 related medical aid issues, the disappearance and misappropriation of funds and material. They arrested the head of the country's energy regulator in a separate investigation. The Maldives, the former vice president was sentenced to 20 years of imprisonment. I know we've seen this, some work we've done in not-for-profit training with various groups in Africa that Gibson Dunn participates in, including with Lawyers Without Borders. Many of the countries in Africa are very open and have been in the last year, even through COVID, to doing online training to combat corruption. in anti-money laundering issues. They still have an insatiable appetite within the Attorney General's offices, especially in parts of East and West Africa, to continue that effort, even with all the problems they are facing. So that's a hopeful sign that there is linkages that were established before COVID with the West and amongst anti-corruption prosecutors in Africa that are continuing. If we can go to the next slide. This is a similar slide as the previous two. It addresses Nigeria. You can see there was the Malibu oil scandal regarding Shell and Eni, their purchase of an oil field with an alleged $1.3 billion corrupt deal made in 2011. The federal government in Nigeria has moved in Milan to order Shell and Eni to pay an advance payment of around $1 billion. This is a development that we've continued to see unabated in the last year, which is that African countries are more frequently than in the past litigating in Western courts to vindicate what they consider to be the effects of corruption. It's not just that they are the passive recipients of outside Western U.S. and Western Europe and other countries enforcement within the continent, but they are reaching out to try to vindicate their rights, and that's a trend you should continue to expect, that the African countries will try to do so. South Africa. Just a month ago, a special investigating unit arrested the General Secretary of the ANC, the African National Congress, for fraud and money laundering. That is not a new trend. That's been happening, the prosecution against the ANC, frankly, for decades. But there have also been reports of corruption affecting COVID-19 distributions, which is a very significant problem in South Africa. And those of you who follow the daily news of involving the COVID-19 virus know that there have been reports of a alleged new strain that emanates in part from South Africa, and of course that's led to many concerns within the country as well. On the next slide, Tanzania. There have been. This is interesting. There are, and the reason why we wanted to point this out is it demonstrates the evolution and the sophistication of corruption, anti-corruption effects and efforts within Africa. So in Tanzania, there is an investigation into the production and distribution chain of its cement industry for market manipulation. So this is not a pure corruption case, but it's an effort to try to attack the way in which corruption affects markets where parties collude with each other and sometimes allegedly pay bribes to government officials in concert with each other. Those of us that have been doing work in Africa have seen that kind of behavior for decades, but it has been very infrequently prosecuted by African prosecutors who go after the more sort of the traditional first stage corruption investigations that you would see under the FCPA 2 decades ago, for instance, with the proverbial bag of cash in a bag. And now they are developing the sophistication to use anti-money laundering and competition laws, for instance, to address these issues the same way that you're seeing in the West and in the United States and in parts of Asia. And then even Zimbabwe, there have been some activity, again, related to COVID. Let's talk briefly about some of the highlights of actions which are still dominated by the involvement of Western authorities. In Mozambique, there's been activity in the last year. 3 former Credit Suisse bankers pleaded guilty earlier this year to bribery and fraud. There's been action involving South Africa. In Ghana, the SEC charged a former executive of Goldman Sachs in the UK under the FCPA in connection with an effort to secure a $2.5 million bribe, to pay a $2.5 million bribe to government officials involving an unidentified Turkish energy company. There have been efforts you can see also Cosmos Energy. And finally, if we can turn to the last slide here that talks about European enforcement actions. Of course, SocGen, Societe Generale, a subsidiary, pled guilty in 2018 to paying bribes of over $90 million to Libyan officials. This is one of many cases involving corruption in Libya. And I want to mention that, and I'll turn back to that in my last couple of minutes because I think that's an instructive final point about what to expect in Africa. The Libyan Investment Authority has been very active in the London courts trying to vindicate the recovery of its funds, which were distributed outbound to various investment groups and funds over the past decade as part of corruption, and they're trying to recover those now. And so that's consistent with the trend that I had mentioned earlier, where they're using Western courts to recover ill-gotten gains. The next slide, which is really the last slide I wanted to talk about. So what we're seeing in Africa is the kind of sad, very sad economic collapse that has its most profound impact on the poorest parts of the world, and much of Africa still remains in that category. And I think what we're going to see, what we're beginning to see already, is that there'll be a race to try to locate and identify underpriced assets, distressed assets in Africa that others will invest in. There'll be an effort by investors to try to find higher rates of return in markets that are not recovering as robustly as would have happened absent COVID. Those are the ripe, fertile circumstances in which the last wave of significant African corruption occurred after the financial collapse and problems in 2007 and 2008 and 2009, which led to corruption in places like Libya and Mozambique and Congo, etc. And we anticipate that we're going to see more of that. A lot of investors looking for opportunities, assets in Africa, and that, of course, can lead to very naturally to efforts to pay bribes to get a critical advantage. So, sadly, Africa might be taking a step back in a way that's more profound than other parts of the world because of the economic impact of COVID. So I'm now going to hand over to Patrick.
Thank you, Joel. I think what we're going to see this year or first quarter of 2022, several major U.S. multinationals will resolve matters arising out of South Africa. So watch that area, because we're seeing coordination between the South African enforcers and the U.S. enforcers on matters. That's a rather new issue. And Patrick can talk probably generally about that. Ladies and gentlemen, for your CLE credit, the code number is a number. It's 6081, 6081. 6081 is your code number. We'll repeat that a couple more times before the end. If you just put that code in the form, we at Gibson Dunn will have it processed for you. Patrick, do you want to take us into Central and Latin America, please?
Absolutely. Thanks, Joe. Turning to slide 51, Latin America and the Caribbean is about half the size, population-wise, of China, India, and Africa. It accounts for about 8.4% of the world's population. It's a relatively young region, and nonetheless, despite its size comparison to those other countries, it's still, of course, a major market for many U.S. and international companies, and some of the countries in the region have very sizable economies. That said, in 2020, we saw a massive dip in GDP across the region. There's about a 7.7% drop in GDP in 2020. We are expecting that in 2021 there will be a rebound. Nonetheless, much like Joel just described for Africa, the real key theme here is that the economic plight in Latin America is one of the leading indicators of serious headwinds for anti-corruption efforts throughout the region. If we can turn to the next slide. Now, I want to cover some of the more significant corruption news in the region, and I will say that the anti-corruption developments in Latin America, as I just suggested, have been fairly modest in 2020. In Brazil, for example, while there's been modest progress with anti-corruption efforts, you also see that there's been an uptick in political turmoil. So first, at a high level, some of the turmoil that we've seen in Brazil in 2020 is with Operation Car Wash itself, the enormously successful series of prosecutions of major companies and officials that really for years have been feeding at the public trough in Brazil. and the prosecution task force had racked up enormous successes, over 400 prosecutions. Well, in October of 2020, and really for some time, the government, various government figures have been pushing for shuttering the Operation Car Wash task force and efforts. The Prosecutor General extended the task force's mandate in October to the end of January, so about 2 weeks from now, and we'll see what happens then. But surely, if the task force is shut down, the investigative imperative around Operation Car Wash will be hampered. There's also an investigation into the president of Brazil, President Bolsonaro, for interference in presidential and in police investigations, including embezzlement allegations that relate to his own sons. So with this political turmoil, anti-corruption efforts in Brazil have taken lesser prominence, but there still is some progress. For example, in August, various federal investigative bodies entered into what's called a technical cooperation agreement, or a TCA. It's still awaiting sign-off from the Federal Prosecution Service, but it's designed to promote more effective interagency cooperation in investigations, essentially to help limit or remedy the piling on effect that many companies that have been under investigation in Brazil are well aware of, where different agencies with different mandates jump into the investigation. There's a concerted effort in Brazil to bring that more under control. Also, of real interest in Brazil is that in December 2019, so at the end of the year prior, a new set of anti-crime reforms were enacted that included, among other things, the statutory framework for prosecutors to resolve cases with non-prosecution agreements. In other words, resolving corporate investigations without convictions, much like in the U.S., in France, and the UK, and that permits settlements short of trial, which is an interesting and helpful development in corporate investigations. In other corruption news, turning to Mexico, major corruption issues have made headlines yet again. The former head of Pemex, the state oil company, has been extradited back to Mexico for bribery. And in a different development, unfortunately dealing with a long-running issue that Mexico has seen and is well known, is the link between drugs and corruption in Mexico. In October, in what was really one of the most stunning arrests of the year, U.S. authorities arrested the Mexican defense minister in Los Angeles. He was on vacation with his family, and U.S. authorities acted without notice to the Mexican government. He was arrested and charged with providing material support to drug cartels. Really stunning set of facts. But shortly thereafter, U.S. authorities had second thoughts and dropped the charges at Mexico's request. Apparently, arresting a corrupt defense minister is bad for diplomacy, and so the defense minister returned to Mexico, where he awaits enforcement action there. 9 months earlier, U.S. authorities had arrested yet another government official here, a former Mexican Secretary of Public Security, for taking bribes to protect the Sinaloa drug cartel. And to date, the government, U.S. government, has not sought to drop those charges. If we can turn to the next slide. Some additional corruption news from around the region. Let's briefly talk about Argentina. The notebook scandal continues. Just a reminder, the notebook scandal involves a former government minister's driver who kept very detailed notes of his side job, which was delivering bribes or the cut from bribes from various businessmen to politicians in different ministries. At least 26 politicians and business people have been charged, and including Cristina Kirchner, the current vice president, the wife of a former president, and herself a former president in Argentina. She was actually recently acquitted in Argentina after a controversial reassignment of her case to a new judge who deemed the notebooks that had been recovered inadmissible evidence against her. Colombia itself has faced has seen some major corruption developments, particularly around a $1 billion highway project that was Odebrecht-led. Odebrecht, the Brazilian construction company, actually completed its DPA and monitorship this year, and nonetheless, the long shadow of Odebrecht's prior corruption activities is still cast across the region. And in Colombia, there was a very large arbitration award that was upheld, canceling that $1 billion highway project in Colombia due to Odebrecht bribes. In addition, other developments include that the president of Colombia, Álvaro Uribe, was released from house arrest. He has been under indictment in Colombia under charges in connection with human rights violations, and he allegedly was trying to bribe witnesses against him, paramilitary witnesses, but he has been recently released from prison. If we can turn to slide 54. Now, despite this slowdown in anti-corruption progress and enforcement in Latin America, U.S. authorities have really continued to busily focus on Latin America. 2020 saw a record year overall for the DOJ FCPA units total fines, and while the bulk of those cases were in other regions or other countries, a large percentage of the FCPA unit's prosecutions related to Latin America. Just quickly, Sargent Marine, a U.S. asphalt products company, resolved bribery cases both in Brazil and in the U.S., where it admitted bribing government officials in Brazil, Venezuela, and Ecuador to win contracts. Vitol, a major energy trading firm that's headquartered in Europe, resolved a bribery case in the U.S. and Brazil with authorities in both countries, where it admitted to paying bribes to Petrobras in Brazil, the state oil company, to receive confidential pricing and competitor information, and also admitted to paying bribes in Ecuador and Mexico. Interestingly, we've seen a trend in recent years where DOJ has really aggressively gone after a category of defendants that it typically in the past would not go after, and that is actual government officials. It's using different statutes to do so. And for example, DOJ charged the two sons of the former Panamanian president, who were indicted for receiving as intermediaries $28 million in bribes from Odebrecht in connection with the Lava Jato or the Petrobras-related scandals in Brazil. If we can turn to slide 55, another significant Latin America-focused prosecution involves an investment company, a Brazilian company called JNF Investimentos. JNF had previously resolved with Brazilian authorities, and this year resolved a sizable FCPA case with U.S. authorities in connection with bribes to state banks and pension funds and others in connection with its investments in the agricultural and meat industry in Brazil. Other investigations that have really been going on for years, and cases have been brought periodically, a significant number of cases have been brought over the last few years, relate to Venezuela, where just a slew of government officials, either employees of state-owned enterprises like PDVSA, the state-owned oil company, or other government ministries, have been prosecuted in the U.S. Individuals and companies in the U.S. who've been bribing the Venezuelan state oil company and other ministries themselves have been prosecuted. And so this year is no different. There are some very significant prosecutions that have been made public related to a number of officials, including the treasurer of Venezuela. If we can turn to the next slide. Now, despite these political developments, and while we've seen U.S. prosecutions on the rise, as I mentioned, Latin America, we really have seen anti-corruption efforts hit a headwind, really on the wane. The efforts throughout the region appear to have stalled due to political interference. Here we've identified a number of different publicly reported complaints, including in Brazil, where the Minister of Justice resigned allegedly because of interference by the president in the replacement of the Brazilian federal police chief, perhaps the equivalent of the director of the FBI. In Guatemala, you've seen the president dismiss or shutter a UN-backed commission, anti-corruption commission, and Honduras followed suit. In Mexico, you've seen that the key political figures, both the president and the Congress, have failed to fund anti-corruption agencies and efforts that were brought about as a result of a widely heralded anti-corruption law passed a few years ago. And in Argentina, you've also seen a failure to fund anti-corruption body, a particular anti-corruption body that's led that office to start withdrawing cases and shifting cases away, investigations away from itself and returning those to prosecutors where they had actually been removed from. Turning to the next slide. So why the headwinds in Latin America? Well, perhaps not surprisingly, economic and political instability have really undercut anti-corruption efforts in the region. And it does appear that many of the major economies in Latin America are backsliding on the anti-corruption front. We've seen this in Brazil, Mexico, Chile, Argentina, Colombia. We've seen presidents, vice presidents prosecuted, major political figures prosecuted, and in some cases successfully, in other cases, judges dismissing those cases at late stages or after shifting of judges. If we can turn to the next slide. But it's not all doom and gloom. There are some bright spots worthy of cautious optimism. For example, in Peru, there's a new commission that's been appointed to or created to appoint and oversee judges to help reduce a number of scandals in Peru that have plagued the judiciary. In Chile, we've seen a massive effort and voter effort to approve the drafting of a new constitution. 78% of the voting public supported the drafting of the new constitution. It's expected to include anti-corruption measures. It's quite a popular effort, and so that remains to be determined, but certainly a popular effort amongst the citizenry to push for reform in Chile. In El Salvador, even small El Salvador with its significant gang crime has gotten in on the story. There's glimmers of progress there. The new president was elected on promises, at least, as well as now having formed an anti-corruption commission that's been backed by various international organizations, such as the Organization of American States. We can turn to 59. Some of the key trends in Latin America, despite the tough year for anti-corruption progress, is that for most Latin Americans, not surprisingly, corruption continues to be a major concern. And what we've seen is, despite that concern, law enforcement and political responses to significant scandals that have been outed in recent years, those efforts have seemingly stalled. Scandals have generated public outrage. In Brazil, for example, they've generated significant prosecutions, but in 2020, we've seen significant pushback from politicians across the region seeking to peel back some of that progress. turning to slide 60, why the retrenchment here? It's likely, of course, related to, as I mentioned earlier, the pandemic and the related economic hit. Latin America is facing the worst economic downturn in 120 years. The governments are starved for cash, and frankly, expediency in many instances taking priority over transparency. And in the procurement space, we've seen significant reporting of corruption around COVID-19 response efforts. We have seen, for example, hundreds of corruption cases in Colombia related to winning government contracts to deliver COVID-related supplies. What I think is one of the more interesting and bizarre developments is in Brazil, a senator whose house was raided by authorities was found with funds in his underpants. And those funds were traced to funds that were set aside for fighting the coronavirus. So I think it's a nice symbol of and unfortunate symbol of what's happening in the region in 2020. But as noted, U.S. authorities continue to focus on the region and really continue to work with a number of their key counterparts throughout Latin America to bring joint actions. Let me turn it over now to Benno Schwartz, my friend and colleague from Munich, to talk about developments in Russia.
Sure. Thank you, Patrick. And there is a reason that Russia is at the end of our country reviews. The recent evolution of the Russian economy has been largely disappointing. So somewhat they are at the last stage at this point. Blaming COVID-19 for this year's problems, I think, is only half of the story. If you look back a decade since the great financial crisis, you will see that the numbers in the Russian GDP were slightly negative, and so the 2020 4% decline is just continuing an unhealthy trend. Apart from COVID-19, you see basically two key factors for that. One is the dependency on the oil price and its volatility in recent years, and secondly, the Western sanctions that were following the 2014 annexation of Crimea. And then you have some institutional challenges in Russia, which would be in particularly demographic challenges. Russia has an aging population, and it's expected to shrink by 7% by 2050. So economic growth, more foreign direct investments would be necessary to support the growing share of retirees in Russia. And on that backdrop, let's have a look at the legislative developments to see whether the developments actually support that need. I'm breaking up this overview in basically two categories that I would label as tectonic shifts and operational changes. So on this slide, we start with the tectonic shifts. You saw first amendments to the Constitution, which brought a number of changes. The ones that were most covered by the press was a resetting of the possible term limits that the president could serve as president for Russia. That would suggest that President Putin could now be serving through 2036 if he were to be reelected in the next two elections. So people were expecting an eternal age with President Putin. But then in December, you had another counter-narrative to that, which were amendments to a certain law that provide immunity to a president that goes out of the office. And these rights to immunity had been enhanced. Now the immunity is almost absolute. It also covers crimes that were committed after leaving the office. So not only the ones he may have committed while being in the office. So that caused a lot of dialogue and discussion whether Putin is now going to step down at a certain foreseeable period in time. Some people think this could be as early as this year. Somewhat untimely, there were news reports from investigative services that a person who is believed to have been his son-in-law at the time, Mr. Kirill Shamalov, was given a significant shareholding in a Russian petrochemical company that was estimated at the time to be around $380 million for a cash consideration of only $100. And these facts were actually confirmed by the company. However, they hastened to add that there were other considerations coming from Mr. Shamalov and that the true value was higher than the $100 price tag would suggest. Nonetheless, I would call all these changes together as tectonic shifts because, in my view, they touch and adversely affect some key fundamentals that are underlying the fight against corruption. You all know its tone at the top, its need for accountability, and it is the rule of law applied and enforced on all levels. Looking at the more operational changes that we saw in Russia last year, I want to point out a few clarifications that were provided by the Russian Supreme Court, in particular with regard to legal entities that can become subject to fines if individuals, employees, agents, or other persons acting on behalf of these legal entities have been making bribe payments. The clarifications are several. I've listed them on this slide. I want to highlight three of them. One is that the payment made by the bribe giver has to be also in the interest of the respective legal entity. So what the court found was, as an example, if the payment of bribe was made to a police officer by a driver to avoid a speeding ticket, it would not make his employer, if that were to be a legal entity, liable, even if the driver drove a company car, because, absent other facts, the bribe had been made by the driver to avoid the individual speeding ticket, not to provide benefits to the legal entity, and therefore the legal entity would not be liable. The second clarification I found important was that if bribes were being made in stages or systematically, the respective amounts will be compounded to assess the relevant gravity level for the purposes of assessing the fine. And then further, the conviction of the bribe payer or the bribe receiver, so the individual offender, is not a necessary requirement in order to levy a fine against the legal entity. It is sufficient if all the objective characteristics of the crime have been determined. The conviction itself is not a relevant condition in this context. And importantly, the Supreme Court also clarified that legal entities may avoid fines when they disclose a crime and or assist in the enforcement activities to prosecute the crime. In the previous two slides, we have provided recent amendments to either side that I labeled tectonic shifts and operational changes. I wanted to spend a minute to explain how corruption has become the central political battleground, and many of the recent changes that we just discussed deeply affect the overall climate in Russia relating to the fight against corruption. And there are basically the two individuals you see on this slide. On the left side, Alexei Navalny, the initiator of a non-profit fund called Fund to Fight Corruption. And he has become well known for his frontal attacks against leading members of President Putin's government and his inner circle. These attacks are basically designed to expose examples of official graft and raise regularly allegations of bribery through a dedicated YouTube channel. And they have become a catalyst for a grassroots movement that demands fundamental political changes in Russia. Also, the EU found that the attempt to poison Navalny in last August with the Novichok nerve agent became possible only with the consent of the Presidential Executive Office and with the participation of the Secret Service, the FSB, and that act led then to sanctions against several Russian state officials. So that is one side of the equation. And then on the other side, you see the Russian Prosecutor General Igor Krasnov, who was appointed Prosecutor General in 2020. He was spearheading the investigations against Navalny's fund to fight corruption for alleged money laundering. It was an effort with 112 prosecutors to prosecute this fund. And on the contrary, the various questions that were raised by FBK that were somewhat obvious questions regarding the source of wealth of certain Russia's top state officials did not prompt the Russian prosecutor to commence any official inquiries. You add that to a very recent new law where information about the property of judges, law enforcement, and controlling agency officials has been rendered confidential information, which in my view is seen as another tectonic shift weakening the fundamental principle underlying the fight against corruption, which is transparency. So the political fight is on, and it is fascinating to observe how in 2020 the UK and the EU started using novel tools from their sanctions toolbox to respond to recent challenges that the Russian government posed in the attempt to silence its critics that raised corruption concerns and cases of official graft. In July, novel UK sanctions followed alleged human rights violations have been applied, and in October, following the Navalny poisoning attempt, EU sanctions within the framework of restrictive measures against the proliferation and use of chemical weapons have been applied against Russian officials and are setting a new tone for future targeted personal sanctions. And then on December 7th, the European Council adopted a global human rights sanction regime that will allow it to target individuals, entities, and bodies responsible for, involved in, or associated with serious human rights violations and abuses worldwide. So we expect to see more of these tools being actually deployed and used in the next month, together with the Russian counter-sanctions that we've also depicted on this slide that are being taken by the Russian government, mainly, of course, as a safeguarding exercise. Moving from higher politics to our risk radar with regard to corruption risk during and following the COVID-19 pandemic. Two industry sections stand out. One is, of course, the Russian healthcare industry, which has lowered the gates to become a sole supplier without a competitive bidding process to allow for a quick supply of medical equipment and treatment in face of the COVID-19 pandemic. While it is understandable to deploy medical devices and medical treatment quickly, this certainly increases the corruption risk in this area. And secondly, the technology sector that leveraged and increased need for digital services and products and is known to have complex sales and distribution models and structures that would allow many ways to hide kickbacks or funnel through the sales channel additional fees or remunerations that could be used for making corrupt payments. Those sectors have been called out by the Russian head of National Anti-Corruption Committee, so be prepared that there will be scrutiny with regard to any type of transactions in this area, and that is why we are calling them out on our risk radar. Also, the recent enforcement actions involving Russia that have been published by the SEC are focused on the healthcare industry. There, I think one of the key lessons learned is that with regard to audits of payments that are being made by subsidiaries, in this case a Russian subsidiary, it is really necessary to take a hands-on, on-site approach, a mere desktop approach to review and monitor potentially illicit payments may fail to identify relevant issues and then could later lead to FCPA or other enforcement actions. Moving on to what is the comprehensive risk mitigation strategy specifically for Russia. I think other than in other countries or more than in other countries, it is required to really see FCPA, OFAC, and AML risks together and address them, if possible, in one go. You will note that there are many overlapping guidances with regard to FCPA, OFAC, and AML risk mitigation strategies and processes. I only call out a few. We have listed more on the slide. One is rigorous know your client procedures when onboarding and when working during the transaction with your business partners. The second one would be adequate resources. I know it's a difficult call in terms of crisis around COVID, but still adequate resources is at the key to provide good services for your compliance group. And then third, a continuous monitoring and auditing of activities using a risk-based approach. So don't let the watchdog down while people are working from home. On the key takeaways, I think this year Russia has evolved from what always was a challenging jurisdiction with significant FCPA exposure to one of the key antagonists challenging the fundamentals underlying the OECD Convention combating bribery. So while you have seen on the operative level some implemented recommendations of the OECD and some positive developments, I think on the more higher government level, you have seen an erosion of checks and balances, and also a poor tone of the top, because it appears that those at highest political levels don't feel comfortable to be held accountable to their own standards, which is basically demonstrated by the lifelong immunity for the president of Russia. The broad use of sanctions is another element which is specifically relevant in Russia, and it adds an additional layer of complexity to your business activities in Russia, and you may want to address that with comprehensive risk mitigation strategies. So far for Russia, I'll turn over to
actually, Benno, we're gonna shorten and because we're at the top of the hour. Ladies and gentlemen, the code again is 6081. Patrick Stokes, if we can turn to slide 81, and maybe you can spend a moment on compliance programs, and then we'll close up.
Sure, Joe, absolutely. As you well know, the compliance focus of the Department of Justice and the SEC in the U.S. has continued unabated. That interest in compliance and legislating that companies need to focus on compliance and internal controls is slowly spreading. So we've seen in 2020 that other countries are starting to get religion in this area. China and India currently have legislation pending, which would require certain internal controls or provide for certain internal controls strictures for companies. And we have seen, for example, in Malaysia that the country and the legislature has passed a compliance defense. So it continues to be a focus in other countries, but really the main focus is in the U.S. Despite not seeing any monitorships in 2020, what we have seen is a change in focus with DOJ and the SEC on compliance, really focusing on three different perspectives of a compliance program that DOJ has set out in its guidance, and that is the program designed well, is it implemented, and is it effective? And really that last piece is where the real focus is for the department and the SEC, and that is, are companies setting up their compliance programs based on risk, their actual individualized risks? Are they deploying their resources around those risks? Are they building their program around those risks? And then are they monitoring their program through monitoring efforts, testing efforts, auditing, in order to identify gaps, problems, issues, conduct that needs to be investigated, and then addressing it through compliance modifications, compliance program modifications. And that's the real story of what DOJ and the SEC are looking for. I know we're short on time. Thank you, everybody. Joe, I'll turn it back to you.
Thank you, ladies and gentlemen. If we can turn to slide 96. regret that we've run out of time. The rest of the slides are reasonably self-explanatory, and you should be able to. We have a host of questions that we frankly did not get to, and we'll follow up individually with the people who've asked those questions. Some are very specific and sound like they're related to a specific fact pattern that clients have. We're honored that you've been with us today. The code again for CLE credit is 6081. We hope everyone in 2021 gets vaccinated as quickly as possible. Would love to see you again at our upcoming programs, one on January 26th on FCPA, at a very deep dive on all of the cases for 2020. And as I mentioned, there's one that just happened last Friday, 2021, last Friday, the first FCPA case in the new year that we negotiated. With that, thank you very much. Please stay safe.